Get started. Welcome, everybody. I want to welcome you to our program today on cross-border divorces, a trip through Alice's looking glass with David Rice and Steve Mihaly. I am Michelle Weiss. I am the tax section chair, and I welcome you today. Before we get started, I have a couple of housekeeping announcements. First is you will receive your MCLE certificate shortly after the program. Your certificate will also be stored in BHBA Plus, our members-only community. Please take a moment to complete the survey that is included with your certificate. The program will be available in a couple of days in BHBA On Demand, BHBA's newest member benefit presented by Lawyers Mutual Insurance Company. And now I'd like to thank our tax section sponsor, Hochman, Salkin, Perez, PC. They've been our perennial sponsors and we appreciate it. The Hochman, Salkin, Perez, PC advantage is experience, an eye for innovation, and a genuine dedication to clients, their families, and their business. In addition to their national practice in civil tax and criminal tax controversies and related litigation in federal and state courts, the firm is also active and successful in handling non-tax matters such as business and estate planning for high net worth individuals and closely held businesses, together with white collar defense and commercial disputes. And now on to our program. I want to introduce our speakers today. We have David Rice and Steve Mihaly, both from KFB Rice, LLP. Mr. Rice has been in private practice since November 1979 as a tax professional. Prior to law school, Mr. Rice worked for the accounting firm of Coopers and Lybrand. Mr. Rice is the sole proprietor of the law firm David Lee Rice PLC, AB rated, and for the last 15 years has been named as one of Los Angeles Magazine's super lawyers. He's a member of the American College of Tax Council, which is a very prestigious group of limited to only 700 members. He's a tenured professor in accounting at Cal Poly Pomona, and he's taught a Masters of Taxation program at Cal State Northridge and Golden Gate University. And he's a certified specialist in taxation with the California Bar, and also a specialist in elder law. Mr. Stephen Mihaly is also a certified specialist in taxation law, and he's a certified specialist in estate planning. His practice focuses on probate and trust law. Mr. Mihaly has been specializing in the field of domestic and international business and tax law for more than 35 years. He advises clients and their families on federal and California income and estate taxation, corporate and partnership LLC planning involving tax-free mergers, reorgs, and divisions, probate and trust litigation, business and succession planning, asset preservation and protection planning, international tax planning, tax controversy representation, and charitable tax planning and tax-exempt organizations. So we are very much looking forward to listening to these two attorneys with a wealth of expertise in the area that they're about to present on. And I am going to hand it off to you. Thank you very much.
Thank you, Michelle. Thank you. Thank you, Jesus. International divorce planning. I don't think if you really look at it and you've done any family law, it's somewhat similar to domestic planning in the sense of you got to figure out what court to go in. Obviously, in LA Superior Court, you go to LA Superior Court. In the international arena, you're going to have a lot more courts to choose from, and we'll talk about jurisdiction in a few minutes. But the concepts in terms of what you do in trying to get assets is almost the same as what you do in domestic planning. The big problem is, and this goes, whether it's an international divorce, even a domestic divorce, is when you're dealing with these trusts that are offshore. We found that in a lot of cases, the spouse knows something, but has no idea how the trust is set up, no idea how the husband has set up the businesses, whether they're owned by the trust, whether he owns them individually, and this can make things extremely difficult. When we're dealing with as we'll find out, a husband who's been born overseas, and who resides overseas, and a couple resides overseas, they go through many years, and somehow the American citizen forgets all the tax filing obligations he or she were supposed to make. So their tax really enters into this thing too. And I think the major difference between international divorce planning and domestic divorce planning is international. Any way you want to look at it is going to be a lot more expensive, because you not only have your family law lawyer located in the United States, you may have your family law lawyer or lawyers located throughout Europe, overseas, or wherever. You may have to end up hiring a tax attorney over there. In the last case we were on, we had a family law attorney, we had a tax lawyer in Switzerland, we had a criminal lawyer in Switzerland. So your clients need a hefty piggy bank to do this. The other big thing is, in terms of finding assets, you almost invariably have to use some of these firms that do, shall I say, they hunt for fraud, where the other spouse has tried to hide the assets, move them in a trust offshore. And sometimes they're extremely successful because, depending upon the jurisdiction, for example, like the Cook Islands, they put it into a jurisdiction which it is very difficult to get that jurisdiction to let any assets out of that trust. And that's where the trustee is located, and that's the law that you're under. So it can be very difficult. Even if we find the asset, there's no guarantee. If you're representing a party that's served with divorce papers, don't immediately assume you're going to respond and file in that other court. You're going to too want to look at jurisdiction at the available courts you can go to, whether you want to file in the US or whether it makes sense to file in Europe. As I said, in the last case we're in, we filed, the wife filed in Switzerland, in the United States, the husband filed in Switzerland, and there's a huge question as to whether or not the California court's going to be able to decide this. And I'll discuss why it's important for this case to be decided, at least initially in the US, before moving on to Europe.
But maybe we should preface this by saying the worst case scenario is when the assets are all concealed in some foreign trust in some tax haven jurisdiction. But if there's assets in the US or a more favorable jurisdiction, then there's a reasonably good chance of recovery. But invariably, when you're dealing with international type of clients, they either set up a foreign trust or do it just before the divorce, and that has its own ramifications.
Yeah, so the easier way of doing things, as Steve pointed out, is when we get presented with financial statements, and we'll talk about that in a few minutes. That is, just like in domestic divorce, probably one of the most important pieces of information you're going to get. You want to go through that very carefully. And if assets are located, for example, not in a trust, but in another country, and in the name of the spouse or spouses, those assets are a lot easier for the courts ultimately to deal with. So if we get a judgment, wherever we get a judgment, you can take that judgment and you're not, at least you're not fighting a trust to get it out of trust, or a corporation to get it out of a corporation. So the key, I think, behind all of this is do as much planning as you can in advance. As in California, you pretty much know what your law is. In international divorce planning, actually the capital of the world for international divorce is England. That's where, if you go back and you start reading cases, whether they be in the tabloids or wherever you find your information. That's where a lot of the Russian oligarchs and their spouses have gotten divorced, because the English courts, they are known to be quite fair in terms of division of assets. They are quite fair in terms of award of alimony. And until just recently, before the Supreme Court ruled in the case that we're going to talk about, that they made it a lot easier to breach a trust. Now with this new Supreme Court case that came down in the last 2 years, it's much more difficult to pierce a trust. It's also much more difficult to pierce a corporation. Also, when you're looking at it, are children involved? How do they treat child custody issues? How do they deal with fraudulent conveyances? What is their fraudulent conveyance? Do they recognize pre and post nuptial agreements? So most jurisdictions do, but some don't. What are their discovery laws? It's important to understand this before you file. And that's why I think before you file in the US or in Europe, obviously you want to engage counsel, where if there is a basis to file in Europe, and talk to the counsel over there as to the remedies in Europe as opposed to the remedies in the United States. Do you have anything to add on that, Steve?
Well, yes, the main problem is you're going to need to hire a number of lawyers to assist, because the laws in different jurisdictions vary so much. Even within Europe, they have significant differences, although EU law governs now more uniformly. Of course, England is no longer part of the EU, so that changes the dynamic also with respect to, let's say, parties that have property or from the UK. So the problem here is, one reason it gets so expensive is you have to hire a lot of lawyers, including tax lawyers, which we'll get to. And then you have to, if you get the judgment in a favorable jurisdiction, then of course you have to spend a lot of money on investigators and other lawyers trying to figure out whether you can collect in those various jurisdictions and from those various entities, whether you can somehow, if not pierce the veil, show that the actual beneficial owner of those entities is the other spouse.
Yeah, so the obviously the key behind that is if you can through discovery get the trust instruments to assist you. One of the things I also think that you need to pay particular attention to is who's all part of the family. When it comes to international divorces, assets move quite freely between nations. They disappear. They may end up in children's names, through trust and things like that. So you need to pay close attention to who all the parties are and to where their allegiances may lie. Now, I think one of the other important things you need to do is consult with your client as to realistic goals. I don't care whether you're a litigator, whether it's family law, whether it's tax law, whether it's litigation. We have to bring our clients down to what's reasonable. So we've spent some time talking to some of these individuals that hunt down assets. And they told us, if you're dealing with $10 million or less, it's not worth hiring them. It's going to cost more to get the assets than perhaps the 10 million. It's between 10 and 25. It depends what the assets are. It may be worth hiring them. And above 25 million, they would probably take the case and do that. One of the things that you have in international taxation, and I'm not talking about the $10 million case or even the $20 million case, but we've had cases, I think, Steve, with hundreds of millions of dollars involved and chasing down these assets where I think in one case, I don't know if you're gonna talk about it or not, Steve, where they actually had a freezing order on a mega yacht. And so we're talking about spending a lot of money there. And they, by the way, they didn't end up with a mega yacht, but there are financing companies that will end up doing this either for a piece of the action, or sometimes they're just going to want to get a smaller percentage plus paid back. So I think the key is managing the client. And part of the problem is the client will understand initially when they come in, look, you shouldn't be going after some of these trust assets because you're not going to get them. And then something triggers a spouse, whether there's anger or something else, they all of a sudden realize. And now they want to go after all these other assets, and then everything changes. The minute they start wanting to go after all these other assets, that's where the expense that Steve was talking about and I am talking about really starts to explode, because now you're hiring all these lawyers in various jurisdictions. You're hiring the headhunter to go after all these assets. And I'm talking about you can blow through 7 figures quite quickly.
Well, yeah, and of course, depends what jurisdiction has and what is the governing law over the divorce. Because in many jurisdictions, you don't have the right to discovery like here or the UK. And so you have to spend a lot of money just to find out where the assets are. And then once you find out, then you have to deal with whether you can actually crack through the entities or not. So you have to spend a lot of money just to find out whether you have a possibility of maybe succeeding. In the case that David mentioned, it was a very famous divorce case involving a Russian oligarch who lived in Switzerland, I believe, and also UK. And the wife got the largest award in history. I think it was like almost 500 million pounds. And she went after his super yacht in Dubai. She got freezing orders, which are injunctions under UK law, which were supposed to be effective in Dubai. She battled for 2 years in Dubai, and ultimately she could not succeed in getting the super yacht. And in the end, she ended up suing her own son, who was hiding with her husband in, transferring money and hiding it and concealing it. And she got a judgment again against the son for 75 million pounds. And she got a settlement ultimately, but it was still like probably 1/10 or 1/5 of what she originally got as a judgment. And so she might have been, and she had to pay 55% to the hedge fund or private equity fund that financed all of this. And so she probably would have been better off trying to do the settlement up front in that scenario. Yeah. So you really have a lot of factors you have to consider, but sometimes you don't know until you get into it, because you don't know whether you can prove that the beneficial owner of these so-called third-party trusts are really independent or the spouse, in fact.
So once you've managed the client's goals, then you need to start reviewing the jurisdiction in terms of what you should be, where you should file. Obviously, one of the things would be current residency. Where was the domicile of parties during their marriage? In one case we had, they had lived in Switzerland for 5 years. The spouse had moved to the US just recently. And it was questionable whether she was moving here permanently or she was just dealing with a couple of the assets here and with the intent to go back to Switzerland. You want to look at jurisdictions where both parties have substantial connections. The client wants a jurisdiction. It may be a requirement that the client has to reside in that jurisdiction for a certain period of time. That takes planning, and you need to get your client to do that. You need to consult with counsel in jurisdiction to make sure that you've covered all your bases before you tell a client that you're going to move there. I'm actually going to cover couple things. Oh, I can't go backwards. Is there any way of getting through this quicker?
Moving forward.
Well, I'm going as quick as I can. So, in the back of the PowerPoint that we've done, we kind of have an appendix of various things. One is dealing with jurisdiction, and the second one will be dealing with finance and assets. So if you take a look at this, is what countries have jurisdiction? Remember, some treat divorce and finance as linked, others as freestanding. In other words, you can get divorced, but you got to deal with the assets, perhaps in other countries. In Switzerland, they have for tax purposes, they have a federal position, and then each state has, it's called a canton, I believe, in Switzerland. And it's similar to a state in terms of where you live. So you've got to figure out what court you're supposed to file in. If you're dealing with same-sex marriage, does this country recognize same-sex marriage? Remember, we're not necessarily in America. Well, each country where real property is situated recognize the court order. So we had a situation where the properties were in Davos, Switzerland, and a couple other places throughout Europe. And the question is, will those places accept an order given by a Swiss court?
Or US court.
Or a US court, as the case may be. Well, each country with possible jurisdiction or income is arising or either party is based, recognize the other maintenance financial orders. In other words, so you get an order for alimony or some type of child support and maintenance, will that be enforced in other countries?
It should be mentioned that in Europe, they don't have very strong alimony laws.
Yeah, so in most places in Europe, they don't have strong alimony. The exception is England.
You're right.
That's why, again, England becomes the capital of divorces. Will a foreign recognition be automatic, or are you going to, if you're in the EU, things are easier. But if you got to come to the US, what are the requirements? Or you got to go outside the EU to enforce these. If you have a foreign judgment and you need to commence it in another country, will that country recognize it? And I think when you're obviously when you're dealing with some of these companies that search down for fraud and assets that are missing, they'll tell you right away, we're going to be able to get into the Cook Islands or we're not. And it's good advice for your client to listen to them. What are the connecting factors between the parties, the relationship in each jurisdiction? What is the separate domicile of each party? What is the separate nationality of each party? What passports does each party hold? All these will bear upon, especially when you have a split where to file on jurisdiction. In the EU, one of the things now, and remember, Brexit, England is no longer part of the EU. But in the EU, it's really simple. He who files first wins in the EU as to EU, not necessarily EU versus the United States. Then they go into the habitual residences. Will any admissions of domicile or residence have any adverse tax implications? I can't tell you, but when we start looking at these cases, especially when I have a US citizen, the number of FBAR violations, 8938 violations, the failure to file corporate documents, failure to file gift tax returns, you add up all these penalties, I don't think anyone will have any money left. And these penalties in the US, a lot of them are draconian. And the IRS has very little, shall we say, patience and empathy. You didn't file on time, a day late, they don't care. one of the other things is look to see if there were any postnuptial agreements or prenuptial agreements. Were there any jurisdiction clauses in there? And can you follow those?
Right, because a lot of them won't be enforceable in many jurisdictions. You may need multiple prenups.
Right. So your prenups, and the question is we had a situation where a prenup was drawn up in Switzerland and it was signed in California, but it didn't comply with California requirements. So it did comply with Swiss requirements, but because it didn't comply with California requirements and it was signed here, is that a legitimate prenup? And then look, we don't know whether we're dealing in Europe or other countries, but I think you got to look at the integrity of the country that you're going to be litigating in. Is there corruption? Or what are the attorney-client privilege rules? Is there a personal or judicial advantage to any one party? If there's a previous family law proceeding, do you have the ability to stop it and file somewhere else? What are the differences in substantive law between where you're thinking about filing, and you probably want to make a checklist to see what's most favorable to your client. What country is most cost effective? Some are very quick divorces. When we were dealing with Switzerland, it seemed like a nightmare. It took forever to get spousal support, and it looked like it could go on for a long time unless the parties agreed otherwise.
That's actually a very interesting issue, because in this, in the UK, they have a special rule where, and there's the judges who are known as, I forgot what they call them, payout. Yeah, judge payouts is what they refer to him to, because in the UK, they will award, let's say the wife is the moving spouse, they will award her payment during the divorce of all her fees and her lifestyle in accordance to her lifestyle. So if she has been living a very high lifestyle, she will be awarded during the divorce, which sometimes can last 5 years or even longer, just the continuation of her lifestyle. Unlike in the US, they may not be awarded so much during the divorce. In fact, that's often a problem, that the spouse cannot fund the cost of this litigation and has to go to private financing when a lot of money is at stake.
So I will be, for time purposes, I'm going to have to let you go through the rest of the slides dealing with jurisdiction, or we're never going to get into this, finish this seminar. Grounds for divorce. Most states have no fault divorce. Does that country have no fault divorce? Or do you have to show something that somebody did something bad to somebody, adultery, something like that? So make sure that you fit those facts. Assets, where you're filing, does that jurisdiction take into, for example, a trust, although it may not invade the trust for reasons, there are some jurisdictions that may say, well, the husband's going to have those assets as a resource. Now, can't do this in London, as a resource, so therefore we're going to allocate more of the other assets to the wife. So it'll be an unequal division. You need to look at the jurisdiction and see how they treat it like that. The good thing about that is you're going to have more than one choice. Whereas if you're in California, you have one choice. Asset division, community or separate property regime. We were told that Switzerland was community property. Well, I got into it and it really wasn't community property. It was community property for purposes of at the time they divorced, but it could have easily been classified as an equitable distribution. So one of the concerns we had, if it was community property and they were, and the wife who filed her tax return to the US only reported some small earnings each year. If it was really community property, theoretically, she would have had to go back and amend all her tax returns. So make sure that the lawyers you're talking to understand what you mean by community property. One of the other things, and I'm gonna move over and turn it over to Steve, is does the jurisdiction allow for an injunctive order? One of the things that if you have all these properties everywhere, so you have homes, you have boats, etc., you probably want to get a freezing order on those assets so nobody can sell those assets or move those assets into a trust or something like that. Make sure the jurisdiction that you're in provides for that. I think that is an extremely important point. Steve, do you want to take it from here?
Yeah, sure. You've got the slide there, conduct of parties. So another factor is, well, is the conduct of the parties relevant to how the assets will be divided? In some countries, it's no fault, it doesn't matter. But in other countries, it can matter. And there you can distinguish between non-financial factors like adultery. Will that be taken into consideration? It can be, even in countries like France. It can be an issue to some degree in Thailand, but in other countries, no. And so it just depends on the country. But more common is economic malfeasance, if you will, being very negligent or reckless with losing money or hiding money, of course. And so that is often a factor in determining division of assets, and often in those countries where you really can't get discovery, which is probably most countries, when it's kind of quite clear that the one spouse is hiding and concealing assets, the court, especially in the UK, will simply take 90% of the assets that they know of and give it all to the spouse who's claiming it, because they know that the other spouse is hiding assets and they can't find out what they are. So the conduct of the parties is important. Of course, fraudulent transfers, we all know about in the US. It's a very important factor. And obviously it will be in the UK also under common law principles. Breach of fiduciary duty, we know about that also under California law, section 721. But in the rest of the world, there's great variety of laws. And so one really has to contact local counsel and find out what their particular rules are, because they vary even within Europe from country to country. Now, some of these factors are even more relevant though for spousal support. So economic fault and as opposed to division of assets. So we can distinguish between spousal support and dividing of assets. Okay, so that's an important factor. Then I mentioned earlier about what are the rules concerning alimony or maintenance, as they call it. So in many European countries, they really don't give alimony unless it's like dire need and the spouse really cannot support herself. Now, in some countries like France, they actually have marital contracts, very common practice. So one would have to know about that and see what that, what the marital contract provides for in a country like France, for instance. So again, one needs to be aware of these issues. And how long is the alimony? Usually it's not for very long, even if you're entitled. Usually it's a lump sum, like especially in the UK. So that would be like a clean break, lump sum payment. Then moving on, enforceability issues. Yes, of course. If you have to try to go and collect against an asset somewhere in Russia, good luck. Or a lot of jurisdictions. In the EU, you have a much better chance, obviously. If it's in a tax haven, it depends, and we'll get into that. If it's just a entity which, like, you have a BVI company that owns a very valuable property in London, you have a pretty good chance of peering through the entity and getting to that asset if it's the benefit. If you can show that the beneficial owner really is the other spouse. When it's a trust, then you have really much more difficulties. That's the worst case scenario.
So one of the keys is when you have these trusts, assuming they're in a jurisdiction that will allow you to go in and get it, you need to obviously look at the terms of the trust. But one of the key factors is if the grantor, that's typically where this is somewhat gender driven. It's usually the husband. Does he or the wife did it? Does she have any beneficial ownership in that trust? If she does, it's a lot easier for a court to break it.
Just to round out some of the issues that as a family, from a family law perspective, you want to think about, and we alluded to before, is you need to think about the procedural issues. So as I mentioned, in many countries, or probably most countries, the discovery rules are nothing like what we have, except in the UK. And that's a real problem. So the other side can play hide and seek games, and there's no sanctions. You're basically doing a treasure hunt to find the assets, and it costs a lot of money to do that. So you need to be aware of that. So in Europe, they don't have common law, of course, they follow civil law. So everything is statutory. So that's another reason why discovery laws don't really exist to the way that we are familiar with them. So one has to be aware of that. Well, will you be able to find all the assets, and how much is it going to cost to do that? You're going to have to get private investigators involved, most likely. On the other hand, as I mentioned earlier, as I alluded to, in the UK, these judges can be very helpful in providing lots of maintenance during the divorce, and also in issuing freezing orders, and they look at the big picture more. They also don't recognize prenuptial agreements very much. So if you have a prenuptial agreement which you're trying to break or enforce, you need to be aware of that as well. So, premarital agreements are often part of high net worth marriages, and it's something that you have to be aware of the laws in different jurisdictions and whether they really recognize them or not. And so that's another factor to consider. And as I mentioned, related to this is that if you can find out what the assets are, but you can't get to them in certain jurisdictions, many jurisdictions, they will take into consideration those assets for purposes of determining how much the division, and that is considered part of the pot, part of the resources that can be divided, even though they can't be obtained because they're in the Cook Islands or someplace. They will still consider those assets for purposes of, especially spousal support if in the UK, and also for purposes of division of assets. So even though you can't get to the assets, you might be able to still get to them indirectly if there's other assets, such as in Switzerland or London or what have you. So one needs to be aware that there may be other ways. If you can't, let's say, pierce a trust or whatever, you might be able to get it to it in a roundabout way.
And that's certainly really important. But again, you really got to understand the law of the jurisdictions. And if you're dealing with trust and you're dealing with areas like that, you want to pick a very favorable jurisdiction.
Right. And then, I mentioned, I touched upon prenuptial and postnuptial agreements, and adultery, whether that can be a factor in how much you were awarded. With respect to child issues, there is a statute the U.S. has. It's a very long name, which I forgot. Uniform Child Custody something. And interestingly, the U.S. it holds themselves accountable pursuant to that law, but other countries don't have to. So, for instance, if an Iranian spouse gets a judgment saying that the child can remain in Iran because the child is living there, and under the Uniform Child Custody law that the U.S. has, there's enough connection to warrant that under U.S. law, the U.S. will have to abide by that Iranian order, even though the Iranians don't have to reciprocate. So one has to be aware of that. Now, of course, there's a specialty unto itself with child abduction rules, where you can either invoke the Uniform Child Custody laws, or more likely the Hague Convention, if it's really if you get into that type of issue. That's a specialty unto itself regarding child custody issues. Let's see. Here, I think. Let's see. I mentioned the discovery issues. That's very key. And England and like California and Australia are good jurisdictions, but civil law countries and Asia like Japan, good luck finding out about the assets. Okay, oh, then finally, about jurisdiction, well, one key issue will be, as I mentioned, it might be better for even a US spouse to litigate it in England if they have connections there, because the English law may be even more favorable than many states' laws. But there could be the opposite issue, which is that a foreign spouse does not want to, or typically does not want to litigate in California anyway, and so they will claim forum non-convenience, that the divorce action should be in Switzerland or wherever, Spain, you have, and so forum non-convenience is a very significant issue, which requires reviewing a number of factors, and they're listed on yeah, I'm not sure. I've got 21, but it's probably more. Declining jurisdiction. Yeah, right. Yeah, so this page, you can see the various factors listed there that go into the forum non-convenience, which also is a relevant issue for just civil commercial litigation, but it particularly relevant for okay, moving on. So you just want to be aware that that will be a big battle and be an expensive battle often in any international divorce issue, because that usually is something that's litigated.
I'm gonna skip all the way to slide 30. Otherwise, we're gonna miss out on some trust property or property in general. As I said a few minutes ago, probably the most important document you're going to get in this through most jurisdictions is a financial statement. And obviously you want to file in a jurisdiction where financial statements are the parties are required to share their financial disclosure. Go through it. Are there K1s? Does anything show an interest in something? If you go through it, and I mean, we looked at the tax returns of one of the cases that we handled, and somebody couldn't live in poverty on what they showed on their tax returns, yet they were living a very high lifestyle. What did that tell me? It told me that somebody, or the husband or the wife, had property somewhere else and they were using that money to live on. And it turned out they had a trust set up and they were just kept borrowing from the trust. The problem is they also, even though they didn't have to, they had a green card, they were filing a US tax return. Well, there's a rule that if you have a foreign trust and you take a loan, the loan has to be a qualified loan. Otherwise, it's treated as a distribution. If it's treated as a distribution, Steve will go into, there are filing requirements. And if you don't make those filing requirements, the penalties can be quite severe. So one of the things I do is I look for, when I'm going through the tax returns, obviously, I'm looking at their lifestyle, I'm looking how they live, I'm looking at all the property they acquired, I'm looking at their K1s, I'm looking to see what foreign statements they filed, like FBARs 8938, dealing with assets overseas, whether they have corporations, LLCs. You want to go through the bank statements. Are there big wire transfers going anywhere? We had a company that was set up that was only supposed to earn $50,000. I think we saw $2 million going through the account. You want to review investment statements. You want to review financial statements. Now, Steve, FinCEN is going to require something. When does that start?
Well, it's effective only in a year, January 1st, 2024, but it's going to affect 40 million entities right out the gate, and probably several hundred million people, and especially international people who have U.S. investments.
So it requires, FinCEN with this new rule will require every entity that you form through a country or a state to report the beneficial ownership, which is going to open up Pandora's box.
If it has, to file with any state, Secretary of State or
right
like that.
So finding assets, again, I think I've pretty much covered that. One of the things you may want to do too is look at public records, court records. real estate records, court records, see if they're in a testamentary trust. In one of the international cases we were involved with, we went through the court system in that country, and we found that there was somebody else that was suing the husband, and we got an awful lot of information based on that. Obviously, the discovery tools, I have laid out interlogs for you, requests for production of documents, subpoenas and depositions. Obviously, I haven't laid out what a deposition is, but things I would ask in an interlog, or I think international lawyers should ask: requests for production of documents, subpoena the information I would request, depositions. You got to remember, people may be located overseas. How are you going to hold those depositions, etc.? Steve, why don't we switch to the tax?
Okay,
Because we only
yeah,
have
we're running out of time.
a few minutes left.
We need to switch to my tax PowerPoint. While he's doing that, I should mention that even on the domestic side, there's these domestic asset protection trusts, which even foreigners might use, in South Dakota or a few other jurisdictions. And they probably are not as good as foreign asset protection trusts, but they still make life difficult if they're properly structured. And even in divorce cases, there are some states have while spouses are exceptions to the normal creditor protection rules, certain states even apply their special asset protection, domestic asset protection trust rules to spouses and even child support, like South Dakota. And there is a famous case that's been out there the last few years called Borsage, which you might want to look up because we're all waiting to see how that turns out. It's been dragging on for some time.
Yeah, these self-settled trust or foreign domestic asset protection trust, you'll probably recognize, like South Dakota, North Dakota, Delaware, Nevada. They have the assets theoretically, as long as you don't break the fraudulent conveyance rules, you're fine. The question is, and the penultimate question is, even though that jurisdiction doesn't allow to break the trust, the question is, what are you going to do if all the divorces in California, and California has in personam jurisdiction over the husband, and the court orders the husband break the trust? We, as it appears based on the case that Steve's talking about, it may, and in that case turns out in favor of the husband. These domestic asset protection trusts are going to be formidable.
However, there are other cases where courts put the husband in jail because he was held in contempt. Like there's this case just recently, the marriage of Harnack. Now that was in Illinois, and he did a Belize trust, and he got a default judgment against him. So some of these probably most of these asset protection trusts don't really work, but some seem to. But it's for the international couples, they invariably use foreign asset protection trusts in places like Cook Islands and where have you, where they don't even recognize most judgments, and they have a short statute of limitations of only 1 or 2 years, and you have to relitigate the whole thing. So unless you can really prove that trust is not for the benefit of the children, but actually for the benefit of the spouse, and prove that they're really the owner, it's a hard nut to crack with foreign trusts.
So I have represent a client's wife. The client owes the IRS probably around $70 or $80 million. Dad had set up a asset protection trust offshore in the Cook Islands for this individual. And it's now year 9 or 10 since the IRS has his judgment, and they haven't been able to touch those assets. If the IRS can't get it, I can assure you your client can't get it.
Yeah, and you will see in the big profile cases that even when they get a significant judgment in the UK or Switzerland, they often just aren't able to collect because the assets are in trust that they cannot crack. Now, if the a trust is a sham, oh, and we mentioned at the outset, there was this UK Supreme Court case that just came down recently that kind of put a damper on the piercing the corporate veil or piercing the trust veil argument. And now it's hard to do that. You have to kind of prove that the spouse is really the beneficial owner, that the trust is truly a sham, and that he's getting all the benefit of the trust and you living off of it. So, you know, that's the bottom line is if the assets are, if there's significant assets in the US or not in a foreign trust or one of these domestic asset protection trusts, but even that you have a better chance with piercing, you're probably going to able to collect. It's the foreign asset protection trusts that are the most difficult. And that's where you maybe want to say, is it really worth it to really pursue regarding those assets?
So Steve, somebody, a US citizen gets married, goes overseas, and is good to live. And husband makes most of the income. Assume it's a community property state. What does the wife have to worry about from a tax standpoint?
Well, yeah, this is the thing. I mean, you're a US citizen and you're signing US tax returns, separate or joint. If it's joint because the husband has a green card, you are joint severally liable. And you have no excuse to say, oh, I didn't look at the return. I didn't ask anybody about whether this is being properly reported and filed. And the thing is that there are multiple international information reporting filing requirements. We were just talking about foreign trusts. Well, one of them, and one of the most dangerous ones, involves having to report foreign trusts and whether you're a beneficiary. And obviously, your husband may be using the funds from the foreign trust to live off of and paying your expenses. So you are an indirect beneficiary at least. And that foreign trust may own foreign entities. So then you have other filing requirements. The foreign trust one is one of the most dangerous ones, because if you don't file the form 3520, as it's called, whenever there's a distribution or deemed distribution, the penalty is up to 35% of the gross value of the either distributions or possibly even the assets if it's community property. So you're talking about enormous penalties, and the IRS is making huge money off of this. And there's many cases where people are discovering the these enormous penalties, which frankly, in the past, I'm talking about 10, 15 years ago, was not really enforced. But in the last 5 years, it's been really starting to be enforced, and the penalties are assessed automatically when you file the form. So to come clean, you need to go into a voluntary disclosure or streamlined program to come clean. Because if you die, that doesn't take care of your problems if you're elderly, because your executor and your trustees, if they're US persons, will inherit the problem and be personally liable for all those taxes that you didn't pay or the penalties that you owe. So anyway, just quickly go through this tax issues. I listed all the potential types of tax for international tax filing forms, and roughly Form 926 is, for instance, whenever you transfer money to a foreign corporation. Form 3520 and 3520 I just mentioned to you is whenever there's a foreign trust or a gift from a foreign person to a US person, and these penalties are draconian. Form 5471 is when you have to report on behalf of the foreign corporation, and it can apply if you own as little as 5 or 10% of the stock. You don't even have to necessarily control the company. And there are very broad attribution rules which you have to be aware of and beware of. So the penalty there is $10,000 per year for failing to file that form. Form 8621 is related to what's called passive foreign investment companies, and that's basically when you have investments in a kind of foreign mutual company, foreign mutual funds, let's say, and you can own as little as 1,000th of 1% of a giant foreign mutual fund, and you have to file that form and report it properly. Otherwise, you're going to be subject to fairly strict penalties because they have a special interest penalty with respect to the so-called PFIC, passive foreign investment company return. I also should mention, if you're a beneficiary of a foreign trust, you have adverse complications too, because any accumulated income in that foreign trust, when it's ultimately distributed to a U.S. person, you will be hit with a special interest charge. Also, any capital gains that that foreign trust earns, which is distributed after the year that it was earned, is no longer capital gain to a U.S. beneficiary. It's treated as ordinary income. These are shockers. But of course, the main point here is that when you have a client who's involved in an international divorce situation, they invariably, one party or the other, is unaware or is, let's say, not being honest with the other spouse, and the innocent spouse may not be able to get out of the problem because the other spouse has left the country, maybe tried to move as many assets out of the country, and the spouse who's left here, she's the one who's going to be liable and the one the IRS is going to go after.
And let me just a second, a few things on the innocent spouse. Number one, if they don't file a joint return, you don't have innocent spouse. It has to be a joint return. I refer you to section 66 and take a look at section 66C specifically. It's very much like the innocent spouse rules dealing with equitable relief. I don't know that FBAR, since they're filed separately and they're not part of the income tax code, they're part of a different code section. I don't know that innocent spouse will even work for that, whether it's section 66 or 6015. So, and that goes with a number of these forms. And we've had situations where the foreign spouse has filed a return here, should have elected form 8833, the treaty, didn't. So, and if they would report all the income now because they didn't make the election, it looks, smells, and acts like tax fraud.
Right, and treaties often come into play if they're especially from, well, we have income tax treaties with most countries. So the
I'm just here to let you know that we're just about at 1:30. So.
Yeah, okay, I'll just 5 more minutes.
Okay, great.
So I'm just going over all the forms on this page, and all of the other subsequent pages goes into more depth about many of those forms. I just wanted to highlight form 8938, which means that you have to disclose all of your foreign assets. There's some exceptions, limited exceptions, but the penalties are, $10,000 a year. Obviously that's a good form to know where your spouse's assets are, but they often don't report them, right? They don't want the spouse to know, or they don't want the IRS to know, et cetera. So just going through the next slides in like 1 second, there's been a bunch of major leaks, Panama Papers, Paradise Papers, Pandora Papers, where they've hacked into major offshore entities' records and revealed all of the financial information of millions of people and millions of pages. So there's tons of information out there about very wealthy people from all over the world who've been hiding assets in these tax havens and tax, foreign trusts and foreign entities, et cetera. And pages 5 and 6 are all about controlled foreign corporation, form 5471, reporting requirements. And as I say, you have to file and report even though you may not control that corporation. And there's very broad attribution rules. And the rules are complex. The same rules apply to controlled foreign partnerships on slide 9, form 8865, and 10, slide 10. And then also, yes, and even to disregarded entities, form 8858. So there's all, and form 5472 is when there is a U.S. entity that's owned by a foreign person. So you may have a client who's married to a wealthy scion of a foreign family with lots of money, and they're gifting money to the U.S. green card holder who's married a U.S. citizen, and they need to file the form 5472, even if it's they own it through a foreign trust with a U.S. LLC. because even disregarded entities, this form 5472 applies not only to U.S. corporations owned by 25% or greater foreign shareholders, directly or indirectly, but also LLCs. Form 8621 is relevant to the PFIX, the foreign mutual fund type of requirement, and they have the special rules. Form 3520 and 3520 on slide 17 and 18, we discussed about the foreign trusts and foreign gifts and the huge penalties that if you don't comply, and if you're even, one day late, they're not going to probably give you a break. You need to go into the so-called streamlined program or the voluntary disclosure program if you have been willfully not complying with the law, which the law doesn't mean necessarily intentional. It simply means, have you been reckless in or should have been filing, but you didn't file. So you have to be very careful about, when you try to come clean.
So on the streamlined approach, if you qualify, great. If you don't, and you have to do a voluntary disclosure, you're potentially looking at a 75% penalty for tax fraud.
Right.
They don't put you in jail, but they do hit you with a penalty.
Right. And then, of course, there's the foreign bank account reports, the FIBAR, which FinCEN imposes, and those can be as much as 50% of the gross value of the account at any time in the past. And these penalties, they're enforcing and going back 10, 20 years ago. So, these things they don't go away also, because when you die, as I say, the executor or trustee will be personally liable to clear up your tax issues. You can even lose your passport if you owe as little as $55,000 to the IRS and you don't pay. Then page 27, slide 27, I'm sorry, I list all the penalties there of all these different forms. So you can, in slide 28. Slide 29 is the different types of programs you can go to come clean, to get your house in order if you have not complied with law. These are very sensitive matters, and one has to be very careful how one goes about doing this, because the penalties are huge, and the IRS is not going to waive or abate these penalties that easily. And there's been more and more cases on these types of failure to file these types of forms. And then slide 31, I talked about reasonable cause. Sometimes you can get penalties waived or abated if you can show reasonable cause. And slide 32. And slide 33, I talk about how the IRS is actually automatically imposing these penalties, and then you have to spend 2 years to try to get them waived or abated. 34 is about the streamlined programs. There's offshore and onshore and streamlined programs where you can get the penalty reduced to as little as nothing or 5% of the gross value. If you're not willful or close or borderline willful. So this is all about the streamlined program, slide 35, 36. And slide 37, the difference between streamlined and going at voluntary disclosure where you may be willful. Quiet disclosures where you just file amended returns won't work. The IRS won't accept that. Then I discussed the delinquent information return program, which is when you don't owe any income, you can do a FIBAR filing, late, come in and file your late FIBARs or your late other information returns, provided that you didn't owe any income, or if you did owe income, you reported it on the return on time. Yeah, so just wrapping it up, I talk about the voluntary disclosure program. That's when you're, kind of borderline intentionally evading. And I talk about what's willful or not willful. I talk about the cases that have come down about distinguishing whether someone was willful or not willful, because look at the penalty on slide 43, $12,555,000.
But
The penalty was reduced to $12,555,000.
There's a case before the Supreme Court, and we'll find out how they rule whether the IRS can impose multiple penalties for FBAR or only one.
Yeah, do they apply the penalty just annually or for every account?
Yes.
And slides 44 and 45 are the most recent cases, the Bedrosian and the Flint cases. Actually, the Flint cases are right out of here, out of Southern California, where they didn't report multiple foreign bank accounts for multiple years. And they got hit with like, I don't know, $2 million penalty. They weren't able to get out of it. So that's basically, in a nutshell, the various international tax reporting requirements that you have to worry about when you have an international divorce, because invariably they probably have not been filing properly. And one spouse is not aware of these filing. The one of them maybe doesn't want to report it and the other one's not aware of it. And that's usually your client. And then she gets the shock of her life that she's on the hook for these huge penalties.
Yeah, thank you so much. That was a lot to digest. It's really great material, and thank you. This will be a terrific resource for anyone who works in this area or needs some information. Really, really appreciate it. Okay, so I want to thank everybody for attending today. This was really a great program, just chock full of phenomenal information, and thank you for, digesting it down as much as possible so it can be accessible for people. I just want to mention that our next program will be on January 10th, and it will be on the ins and outs of tax audits. It'll also be a lunchtime meeting, so please, you can sign up. It's already on the events calendar. And if you're interested in becoming more involved in the section, or you have ideas for programming or anything else that would be interesting to the section, please come to our next section meeting. It'll be on December 15th. It's a morning meeting from 8:30 to 9:30 in the morning, and it's also virtual. All right, everyone. Thank you so much for coming, and have a wonderful rest of your day. Bye-bye.
Bye.
Bye-bye.